I'm in my garden. Why would I step away?
I said put down the tools. Now.
Young man, I live here. I'm gardening. What exactly is the problem?
You're refusing to follow my instructions.
I'm asking for a reason. This is my home.
Sir, I need you to step back from the fence. The voice carried that particular blend of authority and impatience. Sharp, clipped, used to immediate compliance. Judge Harold Watkins didn't look up from the rosebush he was pruning. 73 years old, wearing canvas gardening gloves and a faded Duke University t-shirt, he simply continued working the shears around a particularly stubborn branch. "This is my property," he said quietly. "I'm gardening. I don't care what you think you're doing. I got a call about someone casing houses in this neighborhood, and you matched the description." Now the judge looked up. The officer, young, perhaps 30, with the rigid posture of someone who'd never been questioned, stood on the sidewalk with his hand resting on his belt. His nameplate read Donnelly. What description would that be? Officer Donnelly's jaw tightened. "You need to show me ID. Now." "I don't need to show you anything. I'm in my own front yard. You people always have an excuse." Donnelly stepped onto the lawn, crossing the property line without hesitation. "Last chance. ID or you're going in cuffs." Judge Watkins set down his pruning shears carefully on the garden bench. His movements were deliberate, calm, the economy of motion that comes from decades in courtrooms. "Officer," he said, his voice carrying the same temperature as winter rain, "I strongly suggest you reconsider your next action." Donnelly's hand moved to his handcuffs. "Keep talking and see what happens." It was 9:47 a.m. on a Tuesday morning in Oakmont, a quiet suburban enclave 20 minutes outside Richmond, Virginia, the kind of neighborhood where sprinklers ran on timers, where homeowners association rules governed fence heights and mailbox colors, where a misplaced trash can could generate 3 emails. Officer Jake Donnelly had been with the Oakmont Police Department for 6 years. His record showed competence in traffic enforcement, adequate performance in community policing evaluations, and 2 citizen complaints, both dismissed after internal review. The complaints, filed 18 months apart, shared a common thread: allegations of racial profiling during routine stops. In both cases, the department's Professional Standards Division had found insufficient evidence to sustain the allegations. Donnelly's patrol log that morning showed nothing unusual. A welfare check on Maple Street, elderly resident hadn't collected mail for 2 days, turned out to be visiting her daughter. A disabled vehicle on Route 7, tow truck dispatched. At 9:40 a.m., he'd received a dispatch call, "Suspicious person," for 100 block of Ashwood Terrace. Caller reports unknown black male walking slowly past homes, looking into yards. The caller, a retired accountant named Patricia Brennan, who lived 4 houses down from Judge Watkins, would later testify she'd never seen him before and thought he looked out of place. She couldn't articulate why. Just a feeling. Ashwood Terrace embodied a specific kind of American affluence. Houses set back from the street behind mature oaks and maples, brick facades and professional landscaping, 3-car garages and tasteful exterior lighting. The demographic breakdown told its own story. 87% white, median household income $180,000, median home value $640,000. Judge Harold Watkins had lived at 438 Ashwood Terrace for 11 years. He'd purchased the 4-bedroom colonial after his wife Eleanor passed, downsizing from their larger home closer to the city, wanting something manageable, wanting a garden. The neighbors knew him, mostly. He'd served on the Homeowners Association board for 2 years before declining a 3rd term, citing his judicial schedule. He kept his lawn immaculate. He waved when he saw familiar faces. But Oakmont had that particular suburban anonymity where people recognized cars more readily than faces, where 6 houses down might as well be 6 miles in terms of daily interaction. Officer Donnelly pulled his patrol car to the curb at 9:45 a.m. He'd later say in his incident report that he observed a black male, approximately 70 years old, moving slowly near the fence line between properties, behavior consistent with surveillance. What he actually observed was a man gardening. Judge Watkins had been outside since 8:30 that morning. His routine on non-court days: coffee at sunrise, read the Washington Post on the back deck, then tackle whatever section of the garden needed attention. Today, the roses. They'd grown wild over the summer, and fall pruning was overdue. He wore his Duke t-shirt, a relic from law school, soft from decades of washing, khaki cargo shorts, and New Balance sneakers discolored by grass stains and potting soil. His gardening gloves, leather palms worn smooth, had cost him $12 at the hardware store in 1998. Nothing about this moment should have mattered, but it would cost the city $620,000 and end a career. Harold Watkins had been appointed to the Virginia Circuit Court 22 years earlier. Before that, 15 years as a prosecutor in the Commonwealth's Attorney's Office, 3 years in private practice, and 4 years as a public defender straight out of law school. His judicial record reflected consistency. Firm but fair, meticulous about procedure, intolerant of sloppy police work. Defense attorneys respected him because he actually read motions. Prosecutors appreciated that he didn't waste time. Court staff valued his punctuality and his habit of remembering birthdays. He'd presided over approximately 4,800 cases during his tenure, everything from traffic infractions to capital murder trials. He had a reputation. Not flashy. Judge Watkins didn't seek attention, didn't give interviews, didn't write op-eds. His decisions spoke clearly enough. In 2019, he'd suppressed evidence in a high-profile drug case after determining the traffic stop lacked reasonable suspicion. The local news covered it for 3 days. The police union complained. The evidence stayed suppressed. The case collapsed. In 2021, he'd held an officer in contempt for lying under oath during a preliminary hearing. The officer, a veteran with 17 years on the force, spent 6 hours in the courthouse lockup before the sheriff released him on the judge's order. The officer later resigned. No charges were filed, but the message landed. Judge Watkins understood power. Not the performance of it, the mechanics. He understood that authority derived from legitimacy, that legitimacy required accountability, and that accountability demanded consistency. He'd sentenced wealthy defendants and impoverished ones using the same statutory framework. He'd ruled for police when the law supported them, against police when it didn't. His colleagues on the bench knew him as meticulous. Pre-trial conferences in his courtroom started exactly on time. He read every brief, examined every exhibit, questioned every witness when necessary. His written opinions, clear and thorough, rarely got overturned on appeal. But outside the courthouse, he was simply a man in his 70s who liked gardening. Eleanor had been the extrovert, the one who organized neighborhood barbecues, who knew everyone's children's names, who brought casseroles when someone fell ill. After she died, that social architecture collapsed. Judge Watkins attended homeowners association meetings when required, nodded politely at the grocery store, kept to himself otherwise. Not unfriendly, just private. He didn't speak about his career unless asked directly. Most neighbors knew he was retired. Some vaguely recalled he'd been a lawyer or judge, the details fuzzy. He drove a 13-year-old Honda Accord. He mowed his own lawn. Nothing about his daily presentation announced status or demanded deference, which was exactly how he preferred it. That Tuesday morning, he'd been working on the roses for about an hour when Officer Donnelly's patrol car appeared. Judge Watkins noticed it. A lifetime of courtroom awareness made him attentive to his surroundings, but didn't particularly care. Police cars passed through the neighborhood occasionally. Speed enforcement, welfare checks, nothing unusual. He'd nearly finished the first rosebush when he heard the car door close. Then footsteps on the sidewalk. Then the voice. "Sir, I need you to step back from the fence." The judge's first thought, honest and unremarkable, wrong house. He's looking for someone else. His second thought, arriving almost simultaneously, no, he's talking to me. 22 years on the bench had trained him to recognize certain patterns. The tone, not quite respectful, not quite neutral, carrying that edge of preemptive aggression. The body language, weight forward, hand near the belt, the territorial stance of someone preparing for conflict rather than conversation. He'd seen it in his courtroom. Officers testifying with that same energy, that assumption of automatic compliance, that barely concealed irritation when questioned. Some adapted when they realized where they were. Others couldn't help themselves, even in front of a judge. Judge Watkins set down his pruning shears. He could have ended this in 5 seconds. Could have said, "I'm Judge Watkins. I live here. I'm gardening." Could have pulled out his wallet, shown his bar card, maybe his judicial ID if it came to that. But something in Donnelly's voice, that casual certainty, that complete absence of doubt, made him pause. He'd spent 2 decades watching police work. Good police work and lazy police work. Constitutional police work and illegal police work. He knew the difference intimately. And he knew, with the sudden clarity that comes from pattern recognition, that Officer Donnelly had already decided who Judge Watkins was before asking a single question. So instead of identifying himself, Judge Watkins did what he'd done for 40 years in courtrooms. He observed, he listened, and he let the situation develop according to its own logic. "I said ID. Now." Officer Donnelly's hand hovered over the handcuffs on his belt. The morning sun caught the polished metal, sending a small arc of light across the lawn. A neighbor's sprinkler system clicked on 2 houses down, the rhythmic tick-tick-tick of water hitting pavement creating a metronome for what came next. Judge Watkins straightened slowly. His knees protested 73 years of cartilage wear, the price of a life spent standing in courtrooms. The leather gardening gloves felt suddenly heavy on his hands, dirt packed under the fingernails, the familiar smell of mulch and rose fertilizer still sharp in his nose. "Officer, what articulable facts do you have that constitute reasonable suspicion of criminal activity?" The question hung in the air, precise and clinical. Donnelly's expression shifted. Not quite confusion, but that particular irritation that comes from having your authority questioned in an unexpected way. His jaw tightened. "You're being detained for investigation. That's all you need to know." Investigation of what specific crime? Suspicious activity. Casing houses. Donnelly stepped further onto the lawn, his boots leaving imprints in the freshly watered grass. "Got a call about someone matching your description acting suspicious in this neighborhood." Judge Watkins removed his gardening gloves slowly, 1 finger at a time, and set them on the wooden garden bench beside his pruning shears. The bench was warm from the sun, the wood grain rough under his palm. "What description?" "Black male, elderly, moving between properties. I'm in my own front yard. Gardening. You can see the tools." Donnelly's hand moved to his radio. "Dispatch, show me out with 1 subject at 438 Ashwood Terrace. Possible 4 to 11. 4 to 11. Investigation of suspicious person. I'm going to need you to turn around and place your hands behind your back." "On what legal basis?" "I don't need a legal basis. I've got reasonable suspicion, and you're refusing to comply with a lawful order." Donnelly pulled the handcuffs free now, the metal clinking with that distinctive sound. Not loud, but definitive. "Last chance to do this easy." Judge Watkins didn't move. His voice remained level, the temperature of winter rain. "You don't have reasonable suspicion. Being in one's own yard engaged in visible, lawful activity doesn't constitute suspicious behavior. You've conducted a 4th Amendment seizure. I'm not free to leave, correct?" "Damn right you're not free to leave." "Then you've seized me without articulable facts supporting reasonable suspicion of criminal activity. That's a constitutional violation." Donnelly's face flushed. The morning heat was building, supposed to hit 87 by afternoon, and his uniform was that heavy polyester blend that trapped sweat. A dark line was already forming along his collar. "You want to be a lawyer, you can talk to a real lawyer downtown. Turn around. I'm asserting my 4th Amendment right against unlawful seizure and my 1st Amendment right to remain on my own property. You people always have an excuse." Donnelly grabbed Judge Watkins's arm, his left arm, just above the elbow, gripped tight enough to leave pressure marks on the skin beneath the t-shirt sleeve. The judge's shoulder twinged. Old rotator cuff injury from a college basketball game in 1969. Never quite healed properly. "Turn around or I'll turn you around." The smell of the officer's cologne mixed with fresh sweat. Something aggressively masculine. Too much of it, the kind sold at department stores near the register. Judge Watkins could feel the man's breath, coffee and mint gum, as he leaned in close. Officer, you're committing battery under color of law. I strongly advise. I don't care what you advise. Donnelly yanked the judge's arm backward, spinning him toward the house. Judge Watkins's knee buckled slightly, that same cartilage, that same 73-year-old body that didn't move like it used to. He caught himself against the garden bench, his palm scraping the wood grain, a small splinter embedding in the flesh below his thumb. On the ground. Now. I'm not resisting. On the ground. Donnelly pushed downward on the judge's shoulder, forcing him to his knees. The grass was still damp from yesterday's rain, cold moisture seeping through the khaki shorts immediately. Small rocks pressed into his kneecaps. The decorative landscaping stones Eleanor had insisted on planting around the rosebushes, meant to keep the mulch contained. They dug into his skin through the fabric. The handcuffs came next, cold metal circling his right wrist first. Donnelly cranked them tight, tighter than necessary, the ratchet mechanism clicking 4 times past what was reasonable. The steel bit into the bone, cutting off circulation to his hand. Judge Watkins had seen this in courtroom testimonies hundreds of times. Officers over-tightening restraints, claiming the subject was resistant, when really it was just habit or laziness or cruelty disguised as caution. Left wrist next. Same pressure. Same unnecessary force. You're in violation of your department's use of force policy, Judge Watkins said quietly. His cheek was pressed against the damp grass now, the smell of earth and fertilizer filling his nose. Handcuffs applied with excessive tightness constitute unnecessary force under Graham v. Connor when the subject is compliant and non-threatening. Keep talking, counselor. Donnelly patted him down roughly, hands running along his sides, his pockets, his waistband. The search was aggressive, performative. Let's see what you're hiding. I'm not hiding anything. I'm gardening. Sure you are. Donnelly pulled the judge's wallet from his back pocket, brown leather, worn soft from decades of use. A gift from Eleanor on their 15th anniversary. He flipped it open, standing over the prone man, blocking the sun so his shadow fell across the judge's face. A driver's license, a Costco membership card, a library card, a bank card, $43 in cash. No drugs, no weapons, no outstanding warrants waiting to justify this. Donnelly stared at the license. Harold Watkins. For 38 Ashwood Terrace. He looked up at the house number visible on the mailbox. For 38. The address matched. For exactly 2 seconds, something flickered across the officer's face. Doubt, maybe, or the first whisper of recognition that he might have made an error. But then his expression hardened again, that ego protection mechanism clicking into place like armor. Could be stolen ID. Could be mail fraud. You could be squatting. Judge Watkins, face still pressed into the grass, almost laughed. Almost. In my own yard? With gardening tools? At 9:47 in the morning. I've seen stranger things. Donnelly tucked the wallet into his own pocket. Another violation. Failure to immediately return property not subject to lawful seizure. We're going to sort this out downtown. A car door slammed nearby. Mrs. Chun from across the street, home from her morning walk, her terrier barking in high-pitched yaps. She stopped on the sidewalk, staring. Her phone came out. That distinctive motion, arm raising, the screen catching light. Ma'am, move along, Donnelly barked. Police business. I'm just standing here, Mrs. Chen said. Her voice was shaking slightly, but the phone stayed up. Recording. Delete that video. I don't think I will. Donnelly took a step toward her. I can confiscate that phone as evidence. No, Judge Watkins said from the ground, his voice carrying despite the awkward position. He can't. That would be an unlawful seizure under Riley v. California. Ma'am, you have every right to record police activity occurring in public view. Keep recording. Mrs. Chen's hand steadied. Donnelly whirled back. Shut up. That's a violation of my First Amendment rights. You're also currently committing false arrest, detention without probable cause. Every second you maintain this restraint adds to your civil liability under Section 1983. I said shut up. Donnelly crouched down, his face inches from the judge's. The cologne smell was overwhelming now, mixed with sweat and grass and something else. Fear masked as anger. You don't know who you're talking to. Judge Watkins met his eyes. Cold. Steady. 22 years of staring down hostile witnesses. Lying defendants. Corrupt officials. Actually, Officer Donnelly, I know exactly who I'm talking to. The question is whether you know who you're talking to. Some old man who thinks he's smart. You've made approximately 7 separate policy violations in the last 8 minutes. Each one documented. Each one actionable. Your department's own general orders require reasonable suspicion for investigatory stops, prohibit excessive force against compliant subjects, mandate immediate return of personal property not subject to seizure, and forbid threats against citizens lawfully recording police activity. Your supervisor is going to have questions. Donnelly stood up fast, breathing hard. The morning sun was fully overhead now, heat shimmering off the patrol car's hood, the smell of hot metal and asphalt mixing with the garden scents. His radio crackled, dispatch asking for a status update. He didn't respond. Mrs. Chen's phone was still recording. A second neighbor had appeared now, Mr. Patterson from 3 doors down, also holding up a phone. Then a third, a teenager Judge Watkins vaguely recognized, probably homesick from school, filming from an upstairs window. 3 cameras. 3 angles. Every word documented. Donnelly grabbed his radio. Dispatch, subject is secured. Transporting to headquarters for identification verification. He told you his address matches, Mrs. Chun called out. He lives here. We know him. Step back, ma'am. I'm on the sidewalk. Public property. Donnelly looked at Judge Watkins on the ground, at the 3 cameras, at the quiet suburban street that had suddenly become very interested in his police work. His hand tightened on his radio. He should have stopped. Every instinct, every fragment of training, every self-preservation mechanism should have told him, stop. Check the ID again. Call a supervisor. Walk this back. Instead, he doubled down. On your feet. You're coming with me. Officer Donnelly pulled Judge Watkins to his feet, yanking upward on the handcuffs, leveraging the metal against the wrists, forcing the older man to rise or have his shoulders torqued backward. The judge stood, unsteady for just a moment, his knees stiff from kneeling on the damp ground. Watch your head, Donnelly said, the perfunctory warning required by policy, his hand pressing down on the judge's skull as he guided him toward the patrol car's back seat. The interior smelled like disinfectant and old vinyl. Years of sweat and fear and desperation absorbed into the seats. The cage partition, thick plexiglass scratched from years of angry fists, separated front from back. No door handles on the inside. No window controls. The space designed specifically to remind you, you are not in control here. Judge Watkins sat. The handcuffs bit deeper into his wrists. The car door slammed shut with that heavy, final sound. Donnelly climbed into the driver's seat. He picked up Judge Watkins's wallet again, pulling out the license one more time, looking at it under better light. Harold Watkins. Date of birth, March 15, 1951. Address, 438, Ashwood Terrace. He should have run the name through the system. He didn't. He started the engine instead, put the car in drive, pulled away from the curb, leaving Mrs. Chan and Mr. Patterson and the teenager still recording, their phones tracking the patrol car as it rolled down Ashwood Terrace toward the main road. Judge Watkins watched the neighborhood slide past through the window. The Brennan house where the call originated. The Johnsons' perfectly manicured lawn. The Ramirez family's basketball hoop. 11 years of familiar territory disappearing behind plexiglass. Officer Donnelly, he said quietly. Save it for booking. Officer Donnelly, I'm going to tell you something now, and I need you to listen very carefully. I said save it. My name is Harold Watkins. I'm a judge in the Virginia Circuit Court. I've been on the bench for 22 years. You've just arrested a sitting judge in his own front yard for the crime of gardening while black. The car didn't slow. Donnelly's eyes flicked to the rearview mirror. Sure you are. You currently have my wallet. Inside you'll find my bar card, Virginia State Bar, member since 1979. You'll also find my judicial identification card. issued by the Virginia Supreme Court. I suggest you look at both of them carefully. Silence. Then the car began to slow. Donnelly pulled to the side of the road, half a mile from the judge's house, near the entrance to the neighborhood park. His hand shaking slightly now, he picked up the wallet again, opened it, pulled out the cards Judge Watkins had described. Virginia State Bar Association. Harold T. Watkins, member number 47832. And behind it, Virginia Judicial Identification. Circuit Court Judge. 22nd Circuit. Photograph matching the man in the back seat. The color drained from Donnelly's face. He stared at the cards for 10 seconds. 20. His breathing had changed, shallow now, fast. The air conditioning couldn't keep up with the sudden heat flooding his face. In the rearview mirror, his eyes met Judge Watkins's. The judge's expression hadn't changed. Still calm. Still controlled. Still radiating that same cold authority. You can verify this with a single phone call to the courthouse, Judge Watkins said softly. I'm due in court at 1:30 p.m. for a motion hearing. My clerk's name is Sandra Morrison. The main number is on the back of that card. Donnelly's hand moved toward his radio. Stopped. Moved again. Stopped. You've committed false arrest of a judicial officer, Judge Watkins continued, his voice never rising, never hardening, just stating facts, the way he'd stated facts from the bench thousands of times. Assault under color of law. Battery. Violation of my civil rights under clearly established law. Every second these handcuffs remain on is another count. The radio fell silent. The neighborhood park sat empty in the late morning sun. The playground equipment motionless. The swings hanging still. Officer Donnelly sat frozen behind the wheel, his entire career collapsing into the space between one breath and the next. The handcuffs came off 40 seconds later. Officer Donnelly's hands shook as he worked the key, the ratchet mechanism releasing with small metallic clicks that sounded deafening in the silence. Judge Watkins rubbed his wrists. Deep red grooves pressed into the skin, the kind that would photograph well in a civil complaint. Judge, there was a call and I was just... Stop talking, Judge Watkins said quietly. Everything you say now compounds your liability. Donnelly drove him back to 438 Ashwood Terrace without another word. The judge climbed out, walked to his front door, and went inside. The patrol car sat at the curb for nearly 3 minutes before finally pulling away. By noon, Judge Watkins had made 4 phone calls. The first, to his clerk, explaining he'd need to reschedule the afternoon docket. Personal emergency. The second, to his physician, Dr. Rachel Kim, requesting documentation of injuries, the wrist abrasions, the knee contusions, the shoulder pain from the forced restraint. The third, to Sarah Chun across the street, asking if she'd be willing to provide a copy of her video recording. The fourth, to Marcus Webb, a civil rights attorney he'd known for 30 years, who specialized in Section 1983 cases against law enforcement. Marcus, he said when the attorney answered, I need to file a federal lawsuit against the Oakmont Police Department and Officer Jake Donnelly personally. I have video evidence, witness testimony, and documentation of approximately 7 separate constitutional violations. Marcus Webb had been practicing civil rights law since 1995. He'd sued police departments in 4 states, won settlements ranging from $50,000 to $2.3 million, and he'd never, not once, had a sitting judge as a client. Tell me everything, he said. The deposition occurred 6 weeks later in a conference room at the Oakmont City Attorney's office. Jennifer Carstairs, the city's lead attorney, had been with the municipality for 14 years. She'd defended police misconduct cases before, excessive force claims, wrongful arrest suits, discrimination allegations. Most settled quietly. A few went to trial. The city won more than it lost, or at least broke even often enough to justify the legal costs. This was different. She'd watched the videos 17 times. Mrs. Chen's phone footage, Mr. Patterson's recording, the teenager's window angle. She'd read the incident report Officer Donnelly filed, the one that described Judge Watkins as uncooperative and potentially suspicious, and compared it against the timestamp evidence showing a calm, compliant victim articulating constitutional law while face down in his own yard. She'd interviewed Donnelly 3 times. His story changed subtly with each telling. Small details shifting, justifications evolving. The confidence of that morning evaporating into stammered explanations about reasonable suspicion and officer safety. She'd reviewed his personnel file. The 2 prior complaints. The pattern that professional standards had dismissed but that now, in hindsight, read like a prophecy. And she'd researched Judge Harold Watkins. 22 years on the bench. 4,800 cases. A reputation for fairness so consistent that even defense attorneys who lost in his courtroom respected him. No disciplinary history. No scandals. No ammunition to use against him. The city's insurance carrier, Virginia Municipal Liability Pool, had sent their own investigator. His report was 3 pages long and ended with a single recommendation. Settle immediately. This case is indefensible. Jennifer Carstairs sat across from Judge Watkins and his attorney in that conference room, a digital recorder running between them, and felt her stomach drop as she asked the first deposition question. Judge Watkins, can you describe in your own words what happened on the morning of September 12th? He spoke for 47 minutes. Calm, precise, every detail cataloged, every violation named, every moment documented with the clarity of someone who'd spent 2 decades evaluating police testimony and knew exactly which facts mattered. When he finished, Jennifer Carstairs looked at Marcus Webb and said, "Can we take a brief recess?" She walked to the bathroom, locked the door, and stared at herself in the mirror. The fluorescent lights hummed overhead, that institutional buzz that never quite goes away. The soap dispenser smelled like fake lavender. Her reflection looked tired. The city had no defense. Not legally, not factually, not morally. A sitting judge, arrested in his own yard, for gardening. Video evidence from 3 angles. Medical documentation of injuries. Witnesses who'd known him for years confirming he lived there. An officer with prior complaints and a story that fell apart under basic scrutiny. Any jury would eviscerate them. The insurance company knew it. Jennifer knew it. The city manager, who'd called her personally after reviewing the case file, knew it. Make it go away, he'd said. Whatever it costs. The settlement negotiations took 4 months. Judge Watkins's initial demand, $875,000 plus mandatory retraining for the entire Oakmont Police Department plus Officer Donnelly's termination. The city countered at $200,000 with no admission of liability and no personnel changes. Marcus Webb laughed and filed a formal federal complaint in the Eastern District of Virginia, requesting a jury trial and citing not just false arrest and excessive force, but also a violation of clearly established constitutional rights, the legal standard that strips away qualified immunity and exposes individual officers to personal liability. That was when Officer Donnelly hired his own attorney. That was when the police union issued a statement supporting him, then quietly stopped returning his calls. That was when the city's insurance premiums for the next fiscal year came back 18% higher than projected. The final settlement, $620,000 paid to Judge Harold Watkins. No admission of wrongdoing in the official documents, but a quiet agreement that Officer Jake Donnelly would resign, that the department would implement mandatory bias training, and that body camera footage review protocols would be strengthened. The money came from the Virginia Municipal Liability Pool, technically insurance funds, not taxpayer dollars directly, though of course the premiums were paid with tax revenue. The distinction mattered to the city council's press release. It didn't matter to anyone else. Officer Donnelly resigned on a Friday afternoon in February, 8 months after that September morning. He filed for unemployment. He applied to 3 other police departments in neighboring jurisdictions. None called him back. 6 months later, federal prosecutors charged him with deprivation of rights under color of law, 18 U.S.C. Section 242, a criminal statute rarely deployed but devastating when it lands. The evidence was overwhelming. The video was indisputable. His own incident report contradicted observable reality. He pleaded guilty to avoid trial. The judge, not Judge Watkins, obviously, but a federal magistrate named Patricia Orozco, sentenced him to 14 months in federal prison, 3 years supervised release, and permanent prohibition from working in law enforcement. In the sentencing memorandum, Judge Orozco wrote, "The defendant's actions represent not merely an error in judgment, but a fundamental betrayal of the public trust. When those sworn to uphold the law become its violators, the damage extends far beyond the immediate victim." Officer Jake Donnelly reported to FCI Petersburg on a Thursday morning in August. He served 11 months. The story doesn't end with a prison sentence or a settlement check. It ends with a question that hasn't been answered, not in Oakmont, not in Richmond, not in 10,000 jurisdictions across the country where the same pattern repeats with different names and different addresses but the same fundamental dynamic. What if Judge Watkins hadn't been a judge? What if he'd been Harold Watkins, retired mechanic? Harold Watkins, grocery store clerk? Harold Watkins, anyone without the institutional power to fight back, without the legal knowledge to articulate constitutional violations in real time, without the professional credibility that made his story impossible to dismiss. The videos would have been the same. The handcuffs would have bitten into his wrists just as deeply. The grass would have been just as cold. But would the outcome have been the same? Patricia Brennan, the neighbor who made the initial call, never apologized. She moved to South Carolina 8 months later for unrelated reasons. In a brief interview with a local reporter before leaving, she said she'd only been trying to keep the neighborhood safe, and still thought she did the right thing. The Oakmont Police Department completed its mandatory bias training. Officers sat through 8 hours of scenarios and lectures and case studies. Some took it seriously. Some scrolled through their phones when the instructor wasn't looking. The department's official statistics showed no significant change in stop-and-search patterns in the 18 months following Judge Watkins's arrest. Judge Watkins returned to the bench 6 weeks after the incident. He presided over his docket with the same meticulous fairness, the same careful attention to procedure, the same intolerance for constitutional shortcuts. Defense attorneys noticed he seemed slightly more skeptical during police testimony. Prosecutors noticed he asked sharper questions about the basis for stops and searches. He never spoke publicly about what happened. No interviews, no op-eds, no appearances at civil rights rallies or police reform conferences. When asked by colleagues, he'd simply say, "It's been handled," and change the subject. But the case file remained. Federal court records are public. The videos lived online. The story circulated in legal circles, in police training academies, in community meetings about accountability and reform. $620,000. 14 months in federal prison. One career ended. One reputation shattered. One elderly man forced to the ground in his own garden on a Tuesday morning because someone decided he looked suspicious. The math is simple. The system worked because Judge Watkins had the power to make it work. The question that lingers, the one that should keep us awake, is darker. How many people without that power are face down in their own yards right now, unable to articulate Fourth Amendment seizure or color of law, unable to make the system care, unable to do anything except endure? And if it took a federal lawsuit, criminal prosecution, and more than $500,000 to get justice for a sitting judge with 22 years on the bench, what chance does everyone else have? If you found this story valuable, consider subscribing. These stories matter, and they don't end until we decide they do.